On page 358 of the trial transcript, Special Agent Sotka on the stand. Question: on Thursday, what did you do with regards to the investigation? Well, following up on the June 9th recorded conversation, I'd contacted Whelen and my supervisor and advised them that we had this recording from June 9th, and there appeared to be some very good evidence on it. There might be a murder for hire case. We set up a meeting to have Whelen and my supervisor come in early in the morning, and we listened to the tapes together. This means that investigators and the prosecutor and Sotka's supervisor listened to this June 9th recording a total of 5 times, and there appeared to be some very good evidence on it that there might be a murder for hire case. Yet Sotka testified that he didn't hear the word bomb or the word car bomb.
This is Special Agent Mike Sotka. The date is June 9th, 2010. The time is 6:02 p.m. We'll be going to Edgar Steele's residence in an attempt to make a consensually monitored phone call, actually consensually monitored meet between a confidential source and Mr. Steele regarding a murder for hire case.
Let's see what the coverage was. Make sure we get specific. Or
well, I don't know. I mean, I described to you what triggers uninsured motorist coverage.
Okay.
And that's pretty much what it takes. My only question was going to be if a car bomb blew it up, would that trigger any coverage? Frankly, I don't think it would.
You know, and then when I approached Agent Sotka and asked him why he didn't warn me when the word bomb was on the recording, he told me because he didn't hear it. And you know, and this is actually another lie, because at that time he was giving me the impression that he had only listened to the recording one time. Then come to find out in trial, that recording was listened to at least 5 times by the morning of the 10th. They should have been warning me. They should have, you know, they should have been getting in contact with me the morning of June 10th, the moment they knew that there was a risk of any kind of bomb, because they didn't put only me in danger. They put anybody that was in my car, which included my children, some of my children, included my mom, included my granddaughter. My granddaughter, 2 years old at the time. And anybody else that would have been around me if that bomb would have gone off. And I found it, what? It was on June 9th tape. I found it on June 15th. So that is at least 6 days that they went and without warning me and allowed it to be on my car.
Are you guilty of anything in this case?
Absolutely not. Not one thing. I'm guilty of being naive. I've learned that. There is no prisoner more naive than a lawyer prisoner. Because you know where the rules, where the lines are, and you know what the rules are, so you figure, well, they can't do me. Man, did you get the name of that truck that hit me? Is the way I think, is what I've been saying to people around me for the last year and a half. Because they've been doing the stuff that I know they can't do. At my age, 10 years in prison is a death sentence. It doesn't matter what they give me. It's all, hell, give me 1,000 years, Judge. Put me in the Guinness Book of World Records. It doesn't matter to me.
obviously serious accusations, and the jury believed the accusations.
Well, they didn't hear any defense. They didn't have any choice. The judge, I know how this sounds, the judge literally did not allow me to put on a defense. My key expert witnesses were excluded while they were able to put on anything they wanted. The documentary evidence was selectively presented to the jury to make it look one way when it really was another way. And I was in no mental frame of mind to testify either, but he hadn't even prepared me anyway. I couldn't have testified if I'd had to. Of course, he didn't prepare anybody. He was just there for the money, flying low, quick to get out.
Your expert witness was going to testify about, was it the validity of those audio recordings?
Yes, there were two of them actually. The judge wouldn't let either one of them come into trial and testify. If he had, he would have heard Dr. Papson say that the recordings are so unreliable that they shouldn't even be listened to. If he had listened to Walsh, he would have heard even further, because Walsh pointed out that the voice on the two recordings in many cases wasn't even mine, and that yes, it was a cut and paste job. He identified well over 300 places of what he called anomalies, of the sort that occur when you splice tapes together, take gaps out.
Since 1998 to present, I have done approximately 15 to 25 cases a year. I have been examined as to my credentials and training, and never have I been denied the opportunity to testify. In 2010, I was hired to examine evidence in the Edgar Steele case. From the desktop computer, a CD is generated, and that CD has an audio file in a proprietary format and also a codec. A codec is a key that will open up the proprietary format. Once a codec opens up the proprietary format, that audio file is in WAV. Once the audio file is in WAV, it can be edited, as technician Snyder tells us. If one were of the mind to defeat the security features of F8 recorder, merely one would convert the proprietary audio file into WAV, complete edits. With this edited file, re-record into the F8 recorder, re-download into the desktop computer, regenerate a proprietary CD with the audio file and a proprietary codec, and then one would have a completely authentic edited version of evidence. The security features of the F8 recorder are only secure as the integrity of the people in charge of the device. The people in charge of the F8 recorder in Coeur d'Alene, Idaho cannot properly identify the recorder that was used on the date in question. Going back to K1 recorder and technician Snyder's testimony that he was willing to use a recorder that he knew was not the correct recorder, and the fact that his colleague technician Marc had no objection to using the wrong recorder in an official examination of evidence. To me, as a former police officer, former detective, and just a plain old person, this is very disturbing on many levels. Chain of custody is very important, and integrity is very important when a person does, when it comes to testimony and evidence. And suffice it to say that truth is the firmest pillar of justice, and it's very disturbing to me. In this exhibit, I have marked events that, in my opinion, are electrostatic in nature. There are in excess of 100, and they'd be represented by the red marks, and they're numbered 1 through 100. This is diamond cut 8, and diamond cut 8 marks up to 100. I ran out of markers. I wouldn't need more markers to make my opinion. In my opinion, and the opinion of Dr. Papskin and Dr. Caitlin Gregarios, these events are electrostatic in nature, and they were caused by the original recording device. Or they were caused intentionally by somebody performing edits, which would be a stop and a start.
Have you ever seen audio recordings with this number of anomalies admitted as evidence?
Never, never. Audio evidence in this condition could not be authenticated.
In the tens or hundreds of thousands of hours of audio analysis that you've done in your career, have you ever seen this kind of huge population of electrostatic anomalies?
No, and here we see it in a magnification. The waveform shows us, okay, we have a very quick rise, no sustain, exponential decay, and then the audio and the voltage, the voltage trails off. This is textbook signature for an electrostatic transient. The sound it produced is textbook for electrostatic event. Dr. Caitlin Gregarios identified this as electrostatic event. Technician Snyder didn't bother to look at this event. There are more than 16 electrical transients in those 13 seconds of audio. You can see them, you can hear them. Technician Snyder says this is good audio. Technician Snyder needs a hearing aid.
One of the non-rulings that Judge Winmill made later in the day, line 3, then I think Dr. Papson's testimony would become relevant as corroboration of other evidence. Here he's trying to say that Papson can't testify unless somebody else lays the predicate, and it really, this kind of a non-ruling has no place in federal court. Line 5, again talking about Papson. But without that, it's of very limited probative value. Just suggesting that there is a lot of artifact, if you will, in the recording is substantially outweighed by the likelihood of confusion of the issues and the potential for misleading the jury. Fundamental to our legal system is the notion that the burden of proof is on the government. If the government brings this audio evidence to court, and the defense contests its authenticity, the burden is on the government to prove that the recordings are genuine, and the defense can then put on their evidence and their experts who have opposite opinions, opposite expert opinions, and then it's up to the jury to decide the credibility of these experts. They're supposed to hear two sides of a story. For a federal judge to come out and say that the primary evidence in a case can't be looked at because it would confuse the jury or maybe mislead them, like mislead them into the truth maybe, is simply absurd. Now we're going to fast forward to trial. Page 1306. This is near the end of the trial. Judge Winmill gives a nice concise summary here of what he's ruling as far as the two audio experts for the defense, or what he's ruled in the past. What I was trying to do, and of course I was ruling from the bench, I did not have a chance to write out the decision, simply my attempt to articulate my concerns. I obviously found that Mr. Walsh was not qualified by experience, training, or education to offer the opinions that he was offering. Here, the Honorable Judge Winmill is bringing into the equation the opinions, the conclusions that Walsh drew. And that's not his place. He's not an audio expert. He can't question these opinions. It's just whether or not he has the experience, training, and education to offer an opinion, not the opinions that he was offering. There's a written order to Attorney McAllister by Edgar Steele during the Daubert hearing. We must bring Papson back for the trial, whatever the cost. Papson was going on a long planned vacation, and we'll get into that story in a moment. We must lay a subpoena on Papson and perhaps move to continue. The subpoena is mandatory for our appeal. McAllister totally violates this order.
And he said that Ed did not want Papson subpoenaed. And then he was going back to Ed and saying, I wasn't on board with Ed's wishes. All along, this was false, because if I knew Ed had ordered or had written a directive and said to subpoena Papson, I would have told McAllister to do that.
We have since learned that Mr. McAllister was contacted by investigators in early April before the trial started. Mr. McAllister knew that this indictment was coming. He knew he was in deep trouble. He was trying to curry favor with the government by throwing Edgar Steele under the bus. He didn't do anything. His defense was deplorable. Nobody could figure out why Mr. McAllister failed to make objections, failed to make motions for new trial, make motions for mistrial, make motions to do anything that was in Edgar Steele's favor. And he just sat on his hands the whole time. And as a result, there's almost no record for an appeal.
I've got in my hand United States of America versus Robert T. McAllister et al. 29 count indictment. So this indictment is filed, it's right there at the top. That indictment is filed 11/16/2011 after Ed's been sentenced, after McAllister has botched this trial.
5 days after Edgar Steele was sentenced, this indictment was filed with the court in Denver, Colorado. The indictment was actually issued in July by the grand jury and then sealed and kept hidden so that Edgar Steele wouldn't find out about it. Because if Edgar Steele had known, he would have put in his motion for new trial, hey, the government, which is after me, is also after my attorney. They're investigating, indicting my attorney, and as a result of that, they've compromised my attorney, and I have no way to be properly defended. You can see it in Mr. McAllister's defense in this case.
I'm reading the Denver Post article. It says, in June, that would be June 2011, McAllister agreed to be disbarred for 8 years for twice using client funds for personal use. 2 months later, McAllister told a judge in Idaho that he had provided ineffective counsel to a client convicted earlier in the year of murder for hire. The trial occurred while McAllister was dealing with his possible disbarment. Quote, at the time, I did not recognize the extent to which my mental state had deteriorated, close quote, as a result of his remorse, McAllister wrote.
He knew he was in deep trouble. He was trying to curry favor with the government by throwing Edgar Steele under the bus. He didn't do anything. His defense was deplorable.
Line 5. They're talking about Papson as being the next witness, potentially. He's not in the country at the moment. He's on a trip outside the United States with his wife. This was a long-planned trip. Dr. Papson's wife had become very ill. Her life was at stake. This happened, several years previous to the trial. And Dr. Papson promised his wife, when she got well, he would take her on a once-in-a-lifetime trip. Dr. Papson's wife did recover, and he kept his promise and booked a 1-month luxurious vacation in Bora Bora. About a $50,000 trip. And during the Daubert hearing, Cyndi discussed with Dr. Papson and with McAllister, look, Cyndi volunteered, I'll put up the money for the trip. It's non-refundable, $50,000. Cyndi said, I'll put up the money for the trip, stay here. McAllister says, it's not necessary. And off Papson goes on his vacation, willing, of course, to fly back if he just has, a couple of days' notice. Yes, Papson could have gotten there. It's called jet airliners. It just takes a couple of days. McAllister doesn't fight here. Then the judge imposes this absurd deadline that doesn't allow for commercial air travel to get there. And had the subpoena been put out, the court would have had to wait for Papson to get there.
At the U.S. Supremes, with this filing today, we have given them 2 documented instances of the federal prosecutor, one admitted having listened to recordings, and another where she uses information against me that she only could get from a recording to save herself, by the way, from an ethics charge. We have 2 instances of they opening mail to lawyers that are marked legal mail on the outside, and the addressee is an attorney at law. They actually produced them back to me in discovery with the government Bates number stamps on them. Okay? And then we have 2 instances of information surfacing and being used that was exchanged in confidence with my lawyer in one of those sealed attorney-client interview booths, one in the courthouse, one in Spokane County Jail.
On the first day of trial, Special FBI Agent Michael Sotka took the stand, and the first thing that was done was direct examination by Prosecutor Whelen. Simply from looking at the written records, one can see where Agent Sotka committed numerous counts of perjury. Here Sotka's explained about his training and how he's taught to search an individual before going into an undercover meet for contraband. Of course, you want to make sure that an undercover source goes to a meet with nothing on them, so anything that's on their person they brought out. Here Sotka's talking about $487 that he got from the search on Fairfax, and he says he kept it in his possession this time because we were not at Mr. Michaud's house to give it to him. Mr. Michaud's Fairfax's attorney. Then a few pages later, he goes on to say that he took the money off of Fairfax and gave it to Michaud. Well, both things can't be true, and McAllister never picked up on that or decided not to cross-examine on that. So there's 2 different stories. He gave it to Michaud or he kept it. Then he's asked about hidden money. Was there any more money? No. There's no more money in his wallet or however he carried it. So that's what Sotka said at trial. Let's take a look at the search warrant and, more importantly, the affidavit, the sworn statement that Sotka filled out in support of the search warrant. The black boxes are where I've redacted the Steele's address. You can see this is signed by the magistrate the day before Edgar's arrested at 4:30 in the afternoon, and it's been produced by the government. All these documents you're looking at were produced by the government, and it's easy to tell that because that's their document number in the bottom right corner, Steele 272. Here's the affidavit itself, where Sotka's talking about his background, his training, the classes, and his training in murder for hire cases. Point number 5 is going to be really important in a moment, due to an investigation that started on June 9th, 2010. Factual background about the June 9th meetings and the recordings and the silver and the promise to pay. And then, something never mentioned in court, here's a different amount of money. $561 was located in CW1's wallet, that's confidential witness, and left in the custody of CW1. That's completely contrary to procedures in any kind of undercover operation. You do not want to send somebody in with cash on a murder for hire case. Goes on to say, incredibly, $11,000 was located in his pocket and provided to his attorney. What in the world is Fairfax doing with $11,000 cash in his pocket while he's in Chapter 7 bankruptcy? And whatever happens to this $11,000? And of course, had defense attorney McAllister brought up all these inconsistencies, he would have completely ruined Sotka's credibility. And a very important statement, point 18, this affidavit is submitted in support of an application to search the residence. And you can see it's signed by Sotka and the magistrate. That's document number 282, and the document in front of it is 281. But look here at the top of the page. Sworn to this 17th day of March 2010. Earlier in the affidavit, we just saw where Sotka swears the investigation began on June 9th. This is a huge inconsistency. And had McAllister cross-examined Sotka on this, Sotka's credibility would have been even further destroyed, and the search warrant would have been held invalid. However, now that the trial has been long completed, appellate law does not allow for the search warrant to be challenged again. Obviously, the first thing a criminal defense attorney does, even before taking a case, is to read the search warrant and related documents. Makes sense. One would want to know what the government was looking for and whether or not the search warrant was valid. This is Criminal Law 101, and McAllister couldn't have missed it. The March date does fit with the time Fairfax was selling silver. And putting together the original fake recordings would take some time. Ed had a radio show, was on TV frequently, and so it would have been easy to gather up his words and then patch them into a recording with Fairfax. The evidence here points to Sotka beginning this plot to silence Edgar Steele before March 17th, and then for some reason it was postponed and Sotka didn't keep his paperwork straight. The oil change foiled Sotka's plot. That's why Fairfax's story about how he put the bombs in doesn't add up. Remember, Fairfax stated that he thought the bombs were put in a couple of weeks ago. A lot of Fairfax's confession was vague and or inconsistent, and it was Sotka who was running the investigation and was Fairfax's handler. Whatever the story is about who put the pipe bomb on Cyndi's car, they certainly never counted on her getting an oil change on the day of Ed's arraignment. I'm speculating here, but it seems likely that Sotka coached Fairfax before the local police interviewed him. He had to build a new plot. Then first thing the next morning, he calls FBI headquarters for security information on the recorders so that he can re-edit them and fabricate a new plot. And that's why it took so long for Sotka to present the recordings to Cyndi for her to listen to. He was busy editing them, or somebody was. From my investigation, it looks like there have been 3 or 4 versions of the recordings. However, again, McAllister failed to address these vital issues at trial.
Even though I was talking with Agent Sotka and insisting that I get to hear the recordings immediately, he just continually made excuses after excuses why I couldn't meet with him to hear the recordings. You know, if they had these recordings, they needed to let me hear them, and they needed to prove this to me. And when he knew that I would come back, it was, oh, well, he couldn't meet with me because he couldn't meet with me alone. He'd have to get other agents. Well, I'm going to get another agent. Well, then it was that he was on some other assignment and he couldn't get away. And the excuses just kept changing. I didn't get to hear the recordings until June 21st, which was 10 days later. So I walk in and they do 2 things. The first thing they tell me, oh, well, there is 3 recordings, but the 3rd one isn't ready yet. Now, I didn't say anything to them, but my thinking is going, ready? What does it take to get a recording ready? It didn't make sense. I'm going, what are they doing to that recording that it's not ready? That's what went through my mind at the time. Next thing they do, they slap down a piece of paper, one-page letter saying that they had the tapes authenticated, as if I'm supposed to buy into the piece of paper. All I wanted to do was hear the recordings. I wanted to see if it was my husband that was on these recordings. And then they started out, as they're getting the recordings ready for me to hear, telling me, oh, it's going to be hard to hear and you're not going to be able to hear all of it. And I'm going, well, what good is this equipment? Or what good is the recording if this is the case? But they got it ready and I started listening to it. You know, finally Ed does come on with Fairfax, who they only called the confidential source at the time. And they're talking about chores and water and different things, and I'm going, okay. And it was not very long before all of a sudden the conversations changed to a different subject matter, which started sounding like, well, I guess it could be part of a plot. And I'm sitting there, and all of a sudden I hear the word bomb. You know, I had been pretty much in shock because of Ed's arrest and finding the bomb on June 15th. And then I hear the word bomb and I'm going, the FBI put my life in danger. They had information that they could have been warning me about a bomb. And they never said squat.
And you're quite clear on the 21st of June at the FBI office that you heard the word bomb.
I was very clear.
All right? But what we have on the recordings produced by the government is two words, car bomb.
Yeah, you know, the word car in front of bomb, that didn't show up until the government produced the recordings to the attorneys sometime beginning in February or March. Well, that would have been in 2011. That's when I got to finally listen to the recordings again, that's when I heard the word car in front of the word bomb.
The FBI can't have it both ways. Either the word bomb was on the June 9th recording or it wasn't. If it was on the recording, then I wasn't warned and they purposely put my life in danger. Was that their plan? Remember, I was going to be on federal property on the 15th for Ed's hearing. I thank God every day that the oil change saved me from prison or death. If Agent Sotka and his cohorts didn't hear the word bomb after listening 5 times, then it was added later, demonstrating further tampering with the recordings. This explains why Agent Sotka needed the security information on the recorders the day after I found the bomb, and why it was 6 more days before Sotka let me hear the recordings for the first time.